Attorney Bederow has a number of items as well.
Mr. Bederow.
Thank you, Judge.
Honestly, go fuck yourself, sir. You don't say that, okay? You don't lose a trial where a jury acquits someone and finds them overwhelmingly not guilty and say, I gave my sincere obligation to look into this, and I'm telling you all I saw when she's guilty. Again, respectfully, go fuck yourself.
Swear again like that. That was, no, I mean, whatever. That was, I shouldn't have done that.
A few moments later.
You, as a prosecutor, have got to be out of your fucking mind.
Nose.
Dude, Jimmy, look at those ears.
The ears don't bother me as much.
No, I don't trust a man. I don't trust a man with a lobe like that. No,
really,
not a fucking chance.
The mouth is butthole to me.
Very thin, paper thin.
The nose.
Oh, the nose.
The brow.
Well, listen, I will tell you though, I kind of like a fucked up nose on a guy.
Like a big old honker. I like a big nose.
old nose. Give me that big bitch. You know?
Yeah.
Like, I'm into it.
Come over here. Cluck, cluck.
Yeah.
I see some chickens that went moving on up in my biz, cluck, cluck, running. You gotta be with the kids, the kids, the kids, the kids, the kids, kids.
And I go, oop, clutch, clench, kegel. We did it all. And I go, oh, and what happened? And they go, well, we just got 4,000 plus pages, bitch. And I said, stop it. Show me it. Take me to Unimpound Town immediately, if not sooner. So what happens?
The bitch is here.
Why are you at a football game? Are you a Fonz correspondent?
Well, no, because it's only for men over 30. Okay? Have a great night, boys. Fuck off.
It's been 1 week since you looked at me.
Hey, Blues Clues, motherfucker.
Good morning, loveys. How are we? Today is Sunday, August 17th, 2025. And we are here for Sunday service. Okay? Do you have your coffee, your tea? We've got Mr. Bederow on tap and little old me. On your mark, get set. It's Mr. Bederow time.
Hello.
Good morning, Mr. Bederow.
Good morning. How are you?
I am doing well. I am looking at you, looking like an entirely tanned lanai man, and I am obsessed. You look incredible.
Thank you.
Are you enjoying vacation?
Yes, very much so. We're kind of at the halfway point, so there's a little downtime today. So here I am,
yes,
well caffeinated, and I understand a lot's been going on last week.
There has been, and when I put out the Bederow call, the signal, if you will, I didn't realize how long vacation was, and that is very rude of me. So I apologize deeply that I was like, Mr. Bederow, if you're available, but if you said, you know, today, I knew that I think there was like not great weather too. So like you just had a minute, and we have a hard stop at 8:45, but we're going to get into all of the goodness that is the Commonwealth, right?
It provides a lot of content, as you say. Yes, regularly.
Oh my gosh. And not even the content. It's like, I need the breakdown of you, because to me, you know this, you know, I have a reverence for your ability to break it down for just us regular folk, saying like, what is happening here and what it could mean, what it likely means, and what not to read into. So you are our emotional support attorney, and I am forever grateful. So with that being said, let's cheers. I went to Dunk's, boom, tea. You've got the coffee from the house. I'm obsessed. And let's, if we can, let's get right into, like, I'll do chronological for my brain, but the Morrissey email dump. Oh, I leave my body, 4,102 pages, asked for by whom? NBC 10. We get the drop, and there was, to me, a lot of information that looked very, not just sus, but showed that there was predetermined like intention specifically from Morrissey. And I wanted to get your kind of take on all of them and anything else that.
Oh, you went silent.
I'm sorry. There we go. She's back. But yeah, I just wanted your take on all of that because I got a retweet from you. So I thought I did something.
You know, the NBC receiving of all of the emails and the others who receive those emails, this is just an observation more than anything else. That never happens if we don't push that way back last October. If you recall, we made a discovery demand of them with confirmation that Morrissey did use an iCloud account to do official business. This related to his involvement in a matter in Stoughton, complaining that certain individuals who are well-known in this Aaron Reed Turtle Boy orbit couldn't get protective orders and were complaining, and Morrissey was writing to high-level judges and court clerks and whatnot looking for something to happen, and he was doing that on his iCloud account. We demanded that. That led Karen's attorneys to demand the same. That made it public. And, you know, here we are with now a once again, a larger public scandal. The other thing that's interesting about the emails is many of them are directly relevant and discoverable as it relates to the case that we're involved in right now. They're talking about a client and whatnot, conversations among witnesses. And these were demanded again more than almost a year ago at this point. And it's very interesting that we have not received officially a lot of these emails that were then given in a Freedom of Information Act request, which just once again sheds more light on what are these people doing with regard to their discovery obligations. The other thing that jumps out to me that's interesting about the emails before you get into the substance of them is that, you know, these emails were publicly released in a, again, a, you know, public access. So at the same time, in our case, we're hearing about protective orders, and this can't be distributed. This has to be kept under seal, if you will, impounded, whatever the word is you want to use. So, and this is really emblematic of a DA's office that seems to have no guiding principles or consistency in anything they do. On the one hand, they're throwing them out like candy to the public, but at the same time, as it relates to a certain criminal defendant, they're saying these have to be under a protective order. These should not be seen publicly. Some, not all. A lot of them overlap. I mean, obviously, we're aware, you know, what's under impoundment and what's public, but in essence, they've argued against themselves for keeping these under a protective order. If the left hand of the office is throwing them out to the public and the right hand is trying to say, you know, you can't let these be seen because they're embarrassing people. If you know, again, if there are public releases of communications between public officials, which is public information, okay, they work for the public. There's a reason why the Freedom of Information Act exists. There's a reason why you're not supposed to use private email, and if you do, that they're supposed to be distributed. And there's a reason why, irrespective of whatever email you have to use, if they're relevant and discoverable, they have to be disclosed. And at least at this point, a lot of them have not. But what you see in these emails is a district attorney who basically runs the shop from an iCloud account. That's just, why would that be? There's no logical reason. You know, some of the emails that you've seen released also include emails from Morrissey's iCloud account to his Norfolk DA email, which is not interesting, but for the fact it's showing you he has actual knowledge what he's doing. It's not just you click on your email and, oh, the wrong account came up on my iPhone, if you will. You know, sometimes if you have multiple accounts, he's sending email from account to account. So he knows what he's doing. And the only rational inference that can be drawn is that he, at the time he was doing this, was trying to avoid public disclosure. I mean, I don't think anybody would say that he was comprehending that these emails a year down the line are going to be the subject of a freedom of information request because I use my iCloud. But what he didn't count on was us receiving some information that we did, in which he did this, and digging, which we'll continue to do, and basically expose what is just yet another questionable practice and frankly scandal that comes out of this office, which just does not appear to be on the up and up in everything they do. There's no reason for any of this.
That's the problem, and the comfort level in which he was just sending everything. I was talking to my humans about, I have encrypted emails just as for my nursing job, right? And like, I can't send things to my personal emails, or maybe I could. Maybe there is a way, but like IT makes it so that you're unable to do that. And I was harkened back to the 2016 election with Hillary Clinton, right? Do you remember all that dump with the emails? And I'm like, government, hello, like, and that was long ago. So this is known, and it seems like they're, as usual, the culture that has been pervasive in the Norfolk DA's office just continued, and that was just additional proof.
So I'm going to stay away from anything Clinton related, because I've got them in crosshairs on another matter, which I don't want to get into. But I mean, look, there's no reason for them to be using private email. But in the event that they do, forget the FOIA request in Massachusetts. If there is discoverable evidence, whether it's on private servers or not, they need to turn it over. I mean, one of the emails that's been publicly discussed in this matter was some kind of correspondence between Morrissey and the Attorney General over, whether there's witness intimidation. And there is a response from Morrissey in which he appears to be lamenting, whining, whether he's being sarcastic or not, that, the Attorney General isn't going to do anything. They don't think this is witness intimidation, something to that effect. But everything that the Attorney General wrote, talking about a client who's facing 100 years in prison for this kind of stuff, is redacted. Now, if they want to redact that from the public, that's an issue for the public to deal with, whether that's a proper use of a response to a FOIA request. But that's directly relevant and discoverable in our case. So the question is, why the hell don't we have that? Whether it's under protective order or not, that is directly relevant to the defense in an ongoing criminal case, which is that they were obsessed with getting someone, that they would do anything, that they would cut corners. They did not do a real investigation, that they're weaponizing a statute, looking for this, a way to use it in a way that strikes them as favorable to please certain members of the public. That all is part and parcel to that. And we don't have that, again, as lawyers. So whatever the public gets, whether it should be redacted or not, the real question, which will be addressed at a later date, is why aren't the lawyers getting what is discoverable? And why is the district attorney, who recused himself, getting involved in this matter, and getting involved in this matter on a public email server, talking to the Attorney General of Massachusetts, amongst others? Something's not right here.
Yeah. Something is definitely not right there. Now, with the sum and substance of that, of the emails, the specific one, because we could go through, I thought there was a lot, but the one related to Karen's case that really shooketh me was the Andy Klein, or Andrew from Aperture, who sold his company to Aperture in 2024. He was a new employee there, and ironically, Andrew was also a Mass State police officer for 27 years, 24 of which he had experience in the cars unit, and was like Toyota Techstream certified. He was a Mass State trooper. There are all of these connections, and his name was clearly known. There was a familiarity by DA Morrissey with Andrew, because he said Andy sold his company, right? And then that name, though, wasn't disclosed or he wasn't used with Welcher and Burgess. And I thought, as somebody that was a Mass State Police officer, wouldn't you, that for transparency, why wouldn't that have been used, or why wasn't he part of that team? Because he was reached out specifically because Morrissey knew him in July before even Hank was brought on as special prosecutor.
So what I'll say about that email is this: in the real world, it is true that there are relationships, and people
Yes,
leave government,
of
go
course.
into private practice. And I mean, I have numerous relationships from when I worked in public service that, police officers who are now investigators, whatever. I mean, there's nothing improper per se about somebody you used to work with opens a private company who may have a set of services that may provide for a certain
Right.
case. The problem here, or at least which raises questions, I'm not even going to call it a problem. I'm going to say it's worth exploration.
Okay.
Is so this guy was a Massachusetts State Police guy, obviously knows Morrissey, knows him on a first name basis, and my understanding was involved in the investigation of Morrissey's car crash.
Yes.
Is my understanding. Okay.
That's correct.
And since then he's become Andy and they're buddies, and he's promoting business for him. Now he's promoting business for him to the tune of $400,000 to basically regurgitate work that his incompetent state police had already done. I mean, they did nothing new. Okay. So these are the kinds of questions that get raised. And, why is he, doing that? Why is he recommending him? Is it personal? The way the email is worded, is he telling them we have an opinion here? They're going to give us what we want. Again, the language he used, it's interpretational, whether it was, let's see what he says. And if he's with us, he's with us. If he's not, he's not. But now knowing what you saw with Welcher and Burgess and all of this,
Yeah.
and the complete lack of confidence that anybody has in that office, why would anybody think it wasn't anything other than this guy's going to give us what we want? We'll pay him $400,000. He's my buddy. He'll do the right thing. And, Trooper Paul is not a credible witness, but we'll kind of dress him up through more credible witnesses with the proper degrees. And he'll reach the same conclusion, and we're off and running. And, you just ask yourself, is that on the up and up? Maybe, but I think these people gave away the right to be taken at face value in everything they do a long time ago with a lot of the conduct. And this is the public crisis with that office. Large segments of the public don't give them the benefit of the doubt. There is just an assumption that there's always an angle with what they're doing when it relates to these types of cases involving defendants, that they are just so dedicated and so want to get more than anything. And that's the problem, though, generally with the office. They don't get the benefit of the doubt. I mean, people don't find them credible, and a district attorney's office cannot function properly when the people it serves don't take them seriously, don't believe they're credible, and don't trust their motives. That's not good, but that's where it is.
100%. And so back to, like, I didn't understand, like you were saying, it 100% makes sense that they were, that you build relationships. That is the job, right? You clearly are going to use, specific companies and reconstruction and, whatever, forensics. There are things that you build over your tenure and in your office, right? But it was the lack, in my opinion, of like disclosure of it. Like, why wasn't he on the team? Because you reached out to him and he had a 3.5 hour paycheck. When we found the financials, Andy was paid 3.5 hours.
I mean, look, again, if anybody who does this for a living knows what's going on, that is aggressive billing and almost certainly bilking, and knowing that the DA's office is going to pay. I mean, I would surmise that, this guy Klain, he's the relationship guy. Again, he's not the expert with the skill set required for Karen's trial, but he's billing, I am assuming, 3.5 hours for his conversations with Morrissey, his conversations with Brennan, where 90% of the time, one might expect, they're talking about old war stories and how are the kids and the wife and all that. And I'm billing for my time. Okay. That's, that happens. And you, for 3.5 hours, what is he doing? I don't know. Again, that's for the taxpayers to decide. I mean, you look at the Aperture people and their billing practices, they billed to buy underwear. Okay. They literally, now for $10 or $20 in the grand scheme of life, nobody cares. But if you want to know their level of billing, they billed for underwear for the cosplaying of John O'Keefe to get a new pair of underwear.
Yeah.
Explain that.
I don't know.
They bought those clothes so they could dress up and pretend that Welcher was, John O'Keefe. They, you saw what they testified about the Lexus and what they were going to do with that and who's going to get billed for that.
Yes.
And when you realize that they hired this company, and then you see that the person they rely on is this Burgess who lies about his background, doesn't know the difference between bits or bytes, doesn't know which day he's talking about, and you see that he's appears to be incompetent. The real question that you have to ask yourself before you draw a conclusion about, is this really sketchy or not? Again, it's an appearance to me of sketchiness, but what I'd want to know is, who else did they interview? Who else did they seek? Or did Morrissey tap this company and then the prosecution says, those are our people, they're great, because I spoke to Andy Klein for 3.5 hours. So, or did they look for other vendors? That's what I would want to know. That ought to be the subject of the public, the next FOIA request, is who else did they seek out? Or did they have a phone call with Aperture and hire them on the spot and just agree to pay this sum of money?
Yeah, I want to know too. That's exactly what I want to know. And I did think, though, that I was under the assumption before these came out that it was Brennan who really kind of put the new, the new theories into play, or the new strategy into play. But we know that Hank Brennan didn't sign on until September of 2024.
No, it's all Morrissey. I mean, that's the real takeaway. And again, he's the DA prosecuting the case. I mean, he's allowed to do that. What you generally do not see, and this is not a small office. Again, the scale I'm used to, it's small by comparison, but on a national level, they're not small. They've got 50, 60, 70 prosecutors. They're a major suburban county in a major metropolitan area. This is not Mayberry, where, the DA is the guy who does everything. It is a large enough office where, in essence, he's a figurehead. But what you see in certainly in Karen's case, and you've seen it in the other case, he's got his fingers in every pie. And he's allowed to do that, at least when he's not recused. It's just an observation, okay, that he is deeply entrenched in, hire this one, do this, do that, let's do this. That's very rare in a larger, more sophisticated DA's office. And, in the context of what you're dealing with, he hired for almost, $1 million, $500,000, whatever it was, a new prosecutor, even though they didn't have a conflict of interest. So you can't look at this through a narrow lens in isolation. You look at all of the things going on in this case. You saw his correspondence with the feds back and forth, other things. You saw his response to the federal disclosure before the first trial and his just ignoring it and all this other stuff. And you really beg the question. You say, what's his motive for this? He's supposed to be the leader of the office and has a responsibility to the public trust, not just in getting the so-called bad guys, but not spending taxpayer money like a drunken sailor. And he just pissed it away for nothing. And, again, you go back and say, was there anyone in that office who had the stones to say to him, what are we doing?
No.
As a matter of, this is not a good trial, that there's just not enough evidence. Again, whatever it is. But why are we hiring these people when we now know that, in essence, they just rubber stamped what the state police did and dressed it up a little nicer because Welcher had a few degrees where Paul had nothing? I mean, that's the real takeaway from the difference between the first and second trial as it relates to their data. They just put a better appearance, but it's just lipstick on a pig. It's the same useless information that they tried to dress up.
Yeah, and it's like, so more, some may say, Mr. Bederow, that DA Morrissey has his fingers in the pie and Judd Welcher had his fingers in the paint. Okay. And that is what we learned from Karen Reed trial too, that this is all a bunch of questionable interactions, in my opinion, that should continue to be absolutely looked into. But when you mentioned the pick me letters, I have never seen a man lose control as much as seeing DA Morrissey begging, like OPR, right? The Office of Professional Responsibility. And what are you guys doing? Because it was out of his little grimy, nubby fingers. And he would have absolutely been given the information, but there is just a desperation in those emails that I saw. And then the balls to ask for a cool millie, sending a request letter that we're over budget. And I know to Mariano, right, asking for $1 million to prosecute what they called a simple motor vehicle homicide case.
Look, I mean, not to sound like beating a dead horse, because we've talked about this probably 20 times.
Sorry.
Over the last, no, I'm just saying the question that remains, and that people still are not really asking, and the candidates are not addressing, is being the district attorney, you are not the guy in the courtroom. You have a staff, in this case, I think 50, 60, 70 lawyers whose job is to go out and do justice, whatever that means in any given case. But you are also in charge of the public trust and frankly, public pocketbook. You have limited resources, okay?
Yes.
And you have an obligation to the taxpayers and whatnot. And the question that remains is why it at all did you need, whether it's $10 or $1 million, if there's no conflict of interest, to get a ringer, which is exactly what Brennan was. And that's not even meant to be disparaging to him. But from Morrissey's perspective, nothing says I'm not qualified to be DA, or as much as anything else in this spectacle of the last couple of years, than saying I have no conflict of interest. I'm assigning two lawyers in my office to both trials, but they're not good enough. No one else in my office is good enough or willing, whichever the case may be. So I need more taxpayer money to bring in a ringer, someone I know well, and then to handle the way in the manner that he did, which was disgraceful at public expense.
Yeah.
That's the scandal here. I mean, this guy has no business being in charge of the public trust or the public pocketbook and keeping county residents and visitors safe. I mean, he's financially irresponsible. Ooh. He's essentially admitting that my office lacks competent prosecutors or prosecutors willing to do it, which if they're not willing to do it, then that leads to his judgment of pressing on. It's a disaster. The place is a disaster, but I also don't think that people running for DA, they never phrase it like this. You know, they just issue these little sound bites saying, there's corruption in the office and there's, he used private email and this is inappropriate, but like, there's nothing beyond that and explaining what the problem is and why it shouldn't be this way and what I would do differently, but also recognizing the real scandal, which is the gall of a large DA's office sticking their hand out with hat in hand saying, give me $1 million to prosecute a case, which is a guaranteed loser, by the way, on the merits, never mind the ethics. Okay. It's a guaranteed loser. My people can't handle it. And then at the same time, you have no money in your budget to do anything else. You see a bunch of alleged criminals getting let go because the state can't even afford to get them public defenders.
Yes.
I mean, I don't know that one is necessarily related to the other, but the place is a joke.
It is. It is. And it's sad and it's disgusting and it's rage inducing at times. Now, a question before this said, is that typical to be able to request money the way it was Mr. Bederow, because in the letter it said, I know that you have in other high profile cases, beep, bop, ba. He was doing the ego stroke.
Again,
yeah.
maybe I don't want to speak out of turn. I'm not that familiar with Massachusetts legal culture. They don't have the budgets, admittedly, that I'm used to with large New York City offices or U.S. attorneys' offices, which of course are federal. So I don't know. But one of the other real interesting nuggets here and I don't know the full story about this. I saw this on like a Twitter scroll a week ago, where there was some discussion about dipping into forfeiture money to pay for some of this. That is a scandal if that's true, because forfeiture money is not there to be used to pay for prosecutions and things like that. That's there to provide services and whatnot. And if that needs to be investigated and researched and looked into by not me, I don't have the time or effort or energy, but somebody who cares about corruption or whatnot, if they were using forfeiture money to fund the actual prosecution of Karen or others, that's an A1 scandal. Yes.
Okay. Wow. I would like to look into that further.
Forfeiture is taking assets of people who are accused or convicted of a crime. Okay.
Yes.
They bust somebody for drugs and they have, $2 million of dirty money. Prosecutors' offices will seek forfeiture of that money. And then usually the way that money is applied is to set up services or do things or given away for good purposes. It's not meant to be a fundraiser for the prosecutor's office. Okay. You don't give them incentive to take assets from people accused of crimes to fund prosecutions. That is absolutely a no-no.
Yeah. Highly, highly unethical. And
let me be clear. I read that online in somebody's thing. And I think somebody very credible, by the way, but they posted some paper trail. I just perused it, made a note at the time that better not be true if it is. But to be clear, I have no idea.
It's not been vetted. We're just saying that, but
if that is, somebody ought to hunt that down. And that, though, by the way, those somebodies ought to be people running for DA.
Should be. It should be. Where are we? We're still a little quiet. But I have reached out to a candidate, and I might be having him come on. The Norfolk DA candidate, Craig, is thinking about maybe coming on my show to talk, and I'll ask him all the questions. I will. I'll ask him everything.
They should. I mean, they should be out raising money. And Morrissey is the gift that keeps on giving. But at some point, you can't win by saying I'm not Morrissey. First of all, there's 2 or 3 or 4 of you. And you know how it is. If it gets fragmented, one guy has this core group. Sometimes that's enough. And remember, they're all in the same party, basically. So it's really, because, that's the other problem when you have a one-party state either way.
Yeah.
It's just the prime. Oops, I almost spilled the coffee there. The primary, those were very fast.
You were just quick like a cat on that reflex.
Because I'm heavily caffeinated. But, this is the stuff that they should be doing.
Right.
And distinguishing themselves. But, that's for them to figure out.
Yeah, figure it out. And also I'm nosy. I'm nosy. So I want to know too. And I feel compelled on that one to definitely look a little bit further. Also, I wanted to ask you, Proctor problems. I got 99 problems and Proctor is one. Okay. He's not just one. He might be 98.
Well, look, I've historically called him the albatross that's wrapped around their neck. Alan called him a cancer. That's harsh. It may apply given, again, in a allegorical sense, not a literal sense. But anything that he's got his dirty fingerprints on, in which he has an important role, is potentially compromised. He's just a walking disaster. I understand a lot of his paperwork was released. I have not looked at it. I've been on vacation.
Yeah.
The only thing I even heard or saw, again, very casually, is that he acknowledged that he was the lead investigator. Big surprise, by the way. Like we needed him to tell us that. It does raise other questions about the integrity, of course, of Hank Brennan, Yuri Buchanan, and others who bent over backwards and twisted themselves into logical pretzels to try to prove that he wasn't, which was absurd. So it really calls into question their integrity with obvious facts and all of that. But I mean, Proctor is a disaster. The only other thing I saw about him, I guess, was he tried to rationalize. And what did he try to say about when he was criticizing Karen, that he meant something different?
Yeah.
Which one was it? Which text was it in which he claimed it was a compliment? I don't even know.
Oh gosh.
He said, all I know is I saw something and it was laughable on its face that he was trying to claim it was I mean, the guy just needs to go away. He's not going to get his job back. But you know, look, he has no shame.
Nut bag. It was a nut bag. Like, clearly, because that's
if that's a compliment, if that's a compliment from him, God knows what a complaint or criticism would be. But he's just, look, he's poisoned multiple cases. He's certainly complicated many cases. But he's going to be stuck because, you know, he's still involved in other cases, and he's involved in our case. The counts against him were dismissed, as you know, in our case, but he's not getting off that easy. He's still involved, and, you know, that's not something for public discussion at the moment, but, you know, he's heavily involved, and he'll be forced to come in and deal with this case too. So he's not going anywhere.
Wow. So he said not bag, but he meant to say not bad, right?
That was another Scrivener's error. I mean, honestly, with this guy, just the guy's a joke. He's a dirtbag. He has no credibility. Why he keeps talking about anything is beyond me. I mean, he's got to deal with this. He has to go to court when he has to go. But other than that, the best thing he should do is just find a new line of work, fall on the sword, and seek salvation and try to rehabilitate his public image. Because the more he digs into this, the worse it gets. There's never a situation in which his conduct is going to be defensible, what he did in that case, and probably others. So,
well, speaking of, forgive me, Father, for I have sinned, he needs to go to confession and or his rabbi. But on Tuesday and Thursday, we had hearings. The Walsh hearing on Thursday, I leave my body. You know me. I'm spinning on the rings of Saturn. I hear our judge say this is also applicable to the King, the Johnson, the De Los Santos cases, which I know about Miles King, but now I need to look into Johnson and De Los Santos because these are new names for me, babe. And it's really not meaning regarding Proctor. So there were 3 buckets, Mr. Bederow, of information. And if you can explain the buckets to me, I would appreciate it because I'm feeling a tingle. And what does the tingle say? I don't know. Is it a spidey sense? Is it an allergic reaction? But I'm not sure. But Reed case, all of the prosecution has the discovery. That's under protective order. But they're going to be able to they're asking to see if they can give it to the other cases if it's relevant in said other cases. Then a second bucket is the grand jury and the grand jury transcripts. But then there's non-grand jury, other materials. And Law McGlaw got up and said on Thursday, we don't have that. So to me, my brain goes, what do you mean you don't have that? If you don't have that, that would have all been produced in trial 1, Toohey style, right before trial 1 for Karen Reed when we got the 3,000 whatever page, like all the shits was provided to both the prosecution and defense in the Reed trial. So if Law McGlaw does not have this material or has not been able to view it, is there other federal cases or another federal case that there would be a federal grand jury and other materials?
Maybe. I mean, this is very complicated, obviously. you have to start with principles of federalism. There's a federal
Okay.
government, a state government, and the protective order in this case is a federal protective order
Yes.
that was put in place at the time that they agreed to disclose the TUI disclosure, that to
Mhm.
give some information to the parties, and they made the Norfolk DA's office and Karen's defense team agree to a protective order as a condition of getting those materials,
Mhm.
uh, which apparently the court was notified as well, or whether she knew
Yeah.
it, didn't know, it doesn't matter. And apparently the terms of the protective order were 30 days after the verdict, all material must be returned or destroyed because it's federally protected material, was given for a limited purpose, blah, blah, blah. Now, some of it is already in the public record because it was used at the trial. I mean,
Yes.
that's the ARCA stuff. You can't take back all that.
Right.
Forget all that. But this is where it gets tricky. All the Proctor stuff and other text messages and whatnot were included in those disclosures. And, you know, we don't know exactly everything that might be contained in there. And there could be materials in there that are discoverable under Rule 14 or Brady, more importantly, exculpatory in
Mhm.
other cases, which may be beneficial to Brian Walsh. Again, Proctor's the lead investigator. So if it turns out that there is material in there that would be favorable to the defense in Walsh, then the Constitution says they get it. That's Brady and
Right.
Giglio. Okay. By the way, that trumps everything.
Oh,
That
okay.
defendant's constitutional right should trump everything. So the problem is this:
Odd.
the Norfolk DA has material, some of it, that they recognize is discoverable under Rule 14, may be exculpatory under Brady, and which ought to be disclosed to certain defendants. But
Mhm.
they have a federal protective order saying no. Now, the prosecution is only responsible for disclosing evidence that's in their possession, custody, or control. The problem is this: the evidence is literally in the prosecution's possession. They have it. It's in their custody. They have it. The issue is it in their control? The federal government is saying you can't do it. And
Oh.
they can't violate a federal protective order. So that you need the federal court or the U.S. Attorney's Office and the federal court to turn this out. So what you saw at a hearing last week, which I only saw 10 minutes, but I mean, I'm a
Mm.
lawyer. I understand what's going
Of
on.
course.
Is that the state judge is
Mhm.
saying, if something is exculpatory under Brady or discoverable under Rule 14, you have an obligation to disclose. Now, you may have the federal government pointing a gun at your head saying you can't do it, but if you don't do it, then there are going to be sanctions. I feel your pain, but the defense is entitled to it. Now, if I'm a defense attorney, I'm jumping up and down saying my constitutional right to due process trumps all of this. And
Oh.
if they're not going to turn it over, then you should be dismissing the case. And that you need the DA and the U.S. attorney and the district court, meaning federal court, to figure this out. And if they don't figure it out, then I want severe sanctions, because if they're not going to give me Brady material and they're not going to give me Rule 14 material, that's on them. And ultimately, that's on Proctor. That material wouldn't exist if he wasn't corrupt and stupid. So the fact that you have a problem because there's an ongoing federal investigation, which may be why they don't want to turn it over and
Yes.
reveal sources and methods and evidence, I feel you. That's a problem. But I have a constitutional right to due process. So if the penalty is we can't disclose this material because we don't want to compromise investigations, then the rub of that, the pain factor that goes with that is I, Brian Walsh, or whoever else, if I'm not getting what I'm legally entitled to, then you got to punish the DA, whether
Yes.
it's meant to be aggressive punishment or just, I'm sorry, it is what it is. They have a constitutional and statutory right to it. You're telling us you're not going to give it to them. Again, I feel for you because you have the federal people breathing down your neck and they won't authorize it. But if
Mhm.
you can't fix that problem, the defendant isn't the one who ought to suffer. It's the DA
True.
who suffers. That's the way it is. Now, if there are materials that the DA does not have in their possession, custody, or control, at all, then they can't be forced to disclose what they do not
don't
possess,
have. Yes.
what they do not control, and which they do not have custody of. So if the feds have other materials and the DA thinks they have discoverable material that would help you with Proctor, but I don't have it, meaning the DA, then in all fairness, because it's real easy to shit on the Norfolk DA because it's what you do. But in all fairness, you can't penalize them for not disclosing what is not in their possession, custody, or control, even if it is favorable to the defense. That's not how Brady and Rule 14 work. The key is what's in their possession, custody, or control.
And so, okay, so now walk me through this then, because there was like an urgency to get back into court because they did make some decent progress between Tuesday and then when they came back on Thursday, right? We know that there's a next hearing on August 28th at 2 p.m., but Walsh's trial is in October. And Tipton, Attorney Tipton, is like blacked out because there was a 45-day review period that Law McGlaw said that they were going to assign 2 ADAs to review all this information. And that's where I say it must, or tell me if I'm wrong, but it must be in their possession, but they have not been able to look through it all. They're reviewing it. They need 45 days to review this. It would have already been reviewed if this was only Reed case material, correct?
That's probably correct. If there's unknown stuff, but it's in their possession, custody, or control, they need to look at it. They're going to need to get permission from the feds. And then you run into the other type of problem, which, tends to happen in Norfolk County. You get sandbagged. Okay. And if he has a trial date in October and it's now mid-August and we need 45 days, the man, who, by the way, is probably a sadistic killer, he's entitled to due process and the presumption of innocence. But, there's a lot of pretty compelling evidence that we're all aware of. But he's in jail. He's entitled to a speedy trial. On the other hand, he's left with 2 problems here. He's left with potentially getting a resolution to this issue on the eve of trial, or seeking an adjournment, which is an awful thing to do when you're rotting in jail, right?
Yeah.
I mean, in theory, if he believes that he's going to get acquitted, I don't. But if he believes he's going to get acquitted, then he should want a speedy trial so I can get out of jail.
Yeah.
But he's left with a terrible choice. Try the case shorthanded in shotgun fashion, not even knowing what evidence there is or isn't until right before, or seeking a 2-month adjournment and letting my client rot in jail. And that's not a position that the defense should be in. But these things keep happening in Norfolk County because of Michael Proctor, because the feds are investigating something or were investigating something and may very well still be investigating something. Look, there is a reason why the feds are being very difficult, if that's the word, in not allowing other materials to be given to Walsh. Okay. If it's just Karen Reed stuff that's already in the public record, that makes no sense to me.
Right?
If they're text messages about, balloon knots and go kill yourself and all that kind of disgusting stuff, that's old news. That's out there. Who cares?
Right.
It's got to be something different.
From your lips to the DOJ's ears. I knew, I was like, because it was not.
But let's be clear.
Right.
Let's be clear. The feds are not the bad guys here.
No.
If they have sensitive materials on an ongoing investigation that they don't want to give to the state court trial. Okay. I mean, I understand, and I'm very sympathetic to the defendant's rights. He's entitled to it. Okay.
Right.
The feds want to protect their case. The loser in this situation is the Norfolk DA because of Michael Proctor. They're the ones to blame for this entire mess, even if it's not venal. It's not their fault that they say, look, we have exculpatory material, but we can't turn it over because there's a federal protective order. We can't be held in contempt of a federal order. Okay. So I understand that, but the defendant has a constitutional right to the material. The feds don't budge. The defense wants their material. Something has to give. And what has to give here is that the judge, and I think he's made it clear, he's strongly considering this, and he's correct. The person that has to give here, the loser, is the DA's office, because you have to turn it over. You can't, but you have to. He has a right, a constitutional right to a fair trial. If he doesn't get exculpatory and discoverable evidence, there has to be sanctions. It doesn't mean I'm going to scream and yell at you and say you're corrupt, but the pain quotient in this case goes to the DA. And at the end of the day, whose fault is that? Proctor and the rest of these people. It is what it is. And you know what? I don't think anybody wants Brian Walsh to benefit. The guy's probably a psycho killer. Probably.
Yeah.
He's still entitled to his fair trial. As a defense lawyer, I hate calling him what he probably is. But in this context, even a scumbag is entitled to a fair trial. Okay? You can't make special rules, and you can't use what they call, lawyers call the bad guy rule, right? Walsh is a bad guy, so let's pretend it didn't happen. Not in this county. There's too many bad cases. There's too many bad things going on. The judge is in a terrible position. All right.
Yeah.
Hopefully what happens is the feds come up with some kind of solution. But if they have sensitive materials on a sensitive investigation, they're probably not going to budge.
And I think that it's incumbent and important for us to always say, and I know from you and from learning from you, that when we fight for justice and we believe in our Constitution and our First Amendment rights and everything that we stand for, truth, justice, and doing the right thing, loveys, that also includes like you're saying, the bad guy clause, the bad guys, even though we know, or you think you know, that there is more than enough evidence to show that Brian Walsh is an absolute cold-hearted killer. At the end of the day, he deserves a fair trial, just as every other defendant in this United States of America. And that is fighting for justice, when you also are fighting for those who, although guilty, they deserve all of those rights. And I'm waiting.
You can't make exceptions for bad people, or the whole system will fall.
Yeah.
You need to be even-handed. They have every right to go after Brian Walsh as aggressively as they can. They should. I mean, the public should want that, but you have to do it fairly and competently. And this is why you need a new DA in Norfolk County. They're screwing it up. Now, do I think Brian Walsh is going to get acquitted? Probably not. My bigger concern is he going to get tried? Because there are sanctions here, they could be ultimate depending on what we're talking about. So Walsh ought to be an open and shut case.
Yes.
They have made it so complicated and so crazy. It's the same thing with this Miles King thing. He's probably factually guilty. I mean, based on what little we know, but they have jeopardized the entire case. They have made it incredibly complicated for no reason. And, you keep seeing these cases, and you keep seeing these hearings, and you keep seeing prosecutors have to testify and in pretrial hearings. And that's really not normal. That doesn't happen a lot. Okay. Yes, it's not. Murder defendants generally don't get released because their trial has taken too long and turning over discovery. Every large case that they generally handle that's high profile on some level gets all kind of screwed up. And it seems to me at some point the question is to say, maybe we need a new DA, and maybe the state police that are investigating these cops ain't so good at what they do or aren't so credible. And maybe we should try something different.
It's fumigation time. Okay. That's what we say. Now, Judge Casper, I'm waiting on Judge Casper, who's our federal judge, right? To make, or in that case, rather, for the Walsh, if Casper allows, we just need Casper to order if the prosecution can do it, correct?
Let's talk about how federal court works. Okay.
Okay.
Federal district courts are here. Norfolk County Superior Court is here. Ultimately, the federal court is not going to care. Okay. They're going to care about the federal investigation. And if the U.S. Attorney's Office goes in and says, we have a huge, large-scale investigation that will be compromised, the federal judge is not going to say, but oh my God, Brian Walsh, what do I do? Okay.
Yeah.
And then at that point, it's going to be kicked over to Judge Krupp to do a very hard thing. Okay. That's just, I mean, I'm not saying the federal court is ignorant to the fact that this could help probably a murderer or probably murderers, right?
Yeah.
But ultimately, that's not going to be their concern. Now, if the U.S. Attorney's Office is able to carve out a solution which they can get the material to the defense and not compromise their investigations, then I think in good faith they'll try to do that. But if they can't, they're going to look at the DA and say, sucks for you. What's for lunch? They're not going to care ultimately. Okay?
Yes. Yes. Okay.
It's not how it works in federal court. If there's a solution, they'll come up with one. But if the U.S. attorney tells the district judge that this is sensitive federal stuff, and we can't be turning this over in some state court murder trial, it's not going to happen.
No, not at all. Right. And that's going to trump like just an order of operations. It's PEMDAS, bitches. Like it's always going.
And that's going to then lead Krupp to have to impose sanctions because the DA will not be able to disclose what they concede we have to disclose, but can't.
Okay.
But be very clear. That's not the U.S. attorney's fault. That's not the district court's fault. That's not Brian Walsh's scummy lawyer's fault. That is Norfolk DA's office, the state police, and primarily probably Michael Proctor's fault. That's where the blame goes.
Okay. Yeah. Well, and that makes perfect sense to me. Now, on the heels, though, of interesting that all of this shit is happening on the heels of an April 2025 change in Rule 14, in Massachusetts, right? That like expanded the police officers' roles and the information and exculpatory. It says no longer is it the rule that if you are testifying, you need to turn over exculpatory information. It is everyone involved in the case as of April 2025.
Well, let me start real quick.
Yeah.
Massachusetts can codify whatever they want about when to turn over exculpatory material and how it relates to. And that's wonderful that, in the spring of 2025, that was codified. But the reality is the United States Supreme Court said in 1963, exculpatory material in the possession, custody, and control of the prosecution goes to the defense. That's Brady. That's Brady versus Maryland from 1963. And again, when in principles of federalism, what the Supreme Court says applies to Massachusetts. And the only thing Massachusetts can do, if they want to go beyond the U.S. Supreme Court, they can't counter federal law. They can protect a defendant's rights more under state law. They can expand your individual liberties. They can't restrict. Again, this is all principles of federalism. So you can call it Rule 14. You can call it whatever you want. If the prosecution is in possession, custody, or control of Brady material, they need to turn it over. If they have a good faith basis that it exists, they need to investigate. That's really what the new rule says, which again has been the law since forever.
I know. Yeah. Okay.
So when you tell the prosecutor, you make a good faith basis to believe that you have exculpatory evidence, like, I don't know, in a letter, things like that, letters and crayons and things like that, where you notify the the prosecution that there's a good faith basis to believe you have it. That's telling the prosecutor, go look for it. They have to do that. They have a good faith obligation to be aware. They can't be consciously ignorant. They can't be willfully blind. They can't avoid what ought to be right in front of them. And the new Massachusetts law says they have to consult everyone on the prosecution team or anyone in the DA's office for that kind of information. So that's what they have to do.
Well, thank you very much. I was going to I just thought in all the shit stories, isn't it funny that the codification of this new amendment, right, or in the Rule 14 had just come out due to police misconduct and the cases that they specifically cited. So,
here's
my God.
Rule 14 is primarily a factor for what is automatically subject to discovery. Okay, what the defense is entitled to, which does not necessarily mean exculpatory. It could be very incriminating, but I'm entitled to see the evidence against me, that kind of thing. Brady talks about favorable evidence that is favorable to the defense.
Yep.
They've got, you can't, if a witness tells the DA this didn't happen, they can't, put it in the Brady shredder or down the memory hole and pretend it didn't happen. They need to tell the defense, whether it's in writing or not. So Brady is a constitutional due process principle. It has nothing to do. Rule 14 is a lesser law. It's an important law, but if something is favorable, it doesn't matter what Massachusetts says or doesn't say. It matters what the Supreme Court of the United States says, which is you need to turn it over if the defense is not aware of it.
Period.
Full stop.
Full stop. Full throated. Okay. And here we go. The other area I was very interested in this week was the updates to civil, the motion to dismiss and response from Karen Reed's civil case. Is there any information, or not information, but like opinion that you have, Mr. Bederow, regarding the three, there was four. Gosh, come on, Kim, get your notes. You don't have, she doesn't have her notebook. But it was the NIED, so the negligent infliction of emotional distress versus the intentional infliction of emotional distress. And there were four, it was like count 10, 11, 12, and 13. It wasn't to, dismiss all of it. It was a motion to dismiss those specific counts. And there was an explanation from Peter, the lawyer, who it does actually, that's like his forte.
Yeah, no, that's his field.
Yes. And he was saying, which made so much sense to me, about the very kind of tangible guidelines and objective medical findings in which you need to be like in close proximity to have infliction of emotional distress, because everyone has emotional distress with the loss of a loved one, right?
This is the problem again with real lawyers who practice law and know how lawsuits and criminal cases work versus Twitter trolls who think once again that Karen Reed is the cause of cancer, global warming, and all the ills in the world. Okay.
Correct.
You see a lot of people on Twitter, the usual suspects, the usual trolls with their usual mafias, those types of people who scream and yell and say, what a heartless person she and her lawyers are to say that, the O'Keefes didn't suffer, emotional trauma because they weren't there. And that's how this case should be dismissed. Newsflash. That's the law. Okay. In Massachusetts, lawyers defending a lawsuit use the law. It doesn't mean that what the lawyers are arguing that, Mrs. O'Keefe was not upset.
Of course.
Her son died. Of course she's upset. But under the law for this kind of tort, it doesn't apply in a legal meaning. Okay. And it would be malpractice for Karen's lawyers not to make that argument because it's a winning argument. Okay.
Right.
It is a legal argument. That's what lawyers do. They argue law. What Twitter lawyers and Twitter trolls do is they troll on Twitter. Keep it separate.
Right? Which school are you going to? Are you going to Twitter troll law school, or are you going to trust the lawyer Mr. Bederow, attorney Melanie Little, and Emily D. Baker, who have provided services and have also actually passed bars?
These arguments in legal papers are made all the time.
Right.
These kinds of legal arguments, it's not a big deal. It's only a big deal to the 20 to 30 Twitter trolls and their 800 accounts or whatever they are of people who just want to believe that Karen Reed is the cause of all the world's problems. But they're just clowns. I mean, look, lawyers argue legal points.
Yes.
Twitter trolls argue trolling points for clicks. There's a difference, and the lawyers don't care.
Right. And it's just, yeah. For me, I find it so interesting, and I'm not really interested, or I haven't been interested previously in civil suits. So I'm very uneducated with it. So when I hear and I'm able to gather that information of, oh, that makes sense. Because if we look at it, Loveys, everyone who has ever lost a loved one and had to go to a hospital and unfortunately identify a body, or
It's
and
traumatic.
the grief, it's
Of
traumatic.
course.
That is, of course, but that is within our human realm, and there is
The
no egregious, and there is no infliction onto you by that
legal sense.
specific act.
The law is not set up and equipped in a manner where every single person gets to sue everyone else for something awful that happened
God
with
forbid.
certain
Yeah.
degrees of separation. And it's not a perfect system. That's the reason why prosecutors have a lot of immunity, okay? Because the system can't handle and function if every acquitted defendant or every defendant who says I was wrongfully charged can sue every prosecutor every day. Okay, the people who created the laws and implemented them, and the courts that interpret them, there is some method to the madness. So just get off the Twitter law school. This is what they argued. It would have been literally malpractice
To
and
not.
incompetence not to. Why? Because they're going to get criticized online by troll mafias. I mean, get over yourself.
Right. And specifically with what I found was the 4:30 a.m. So it was every single person we had already said that had seen, God forbid, anybody be injured. There are specific torts that can happen if, let's say, for example, you see someone, you're like standing next to your husband, let's say, and he is struck by a vehicle when you're on the sidewalk, right? Like a motorcycle comes up and strikes him. God forbid, I'm so sorry. But that could be a example of that is reckless negligence, or you could say whatever from
Yes,
the
the
motorcycle
idea
operator.
is that you have seared in your mind an image of just a
Proximity.
horrifying
Yes.
impact, a gory looking body. I saw it on whatever. But I mean, what the law does not accept is, like, if God forbid somebody's close relative was murdered in a horrible way, okay, and they had a really close sibling who lives in California, the law does not say that the sibling in California gets
Is
to sue them.
entitled. Yeah.
Okay, that's all they're arguing, and
That's it. That's it.
this is all a nothing burger in a legal sense. It doesn't mean that there are, oh my God, she's a wretched person who says that the O'Keefes didn't suffer. Okay, that is a lazy, ignorant take by Twitter trolls. That's it. It's not even worth 30 seconds more discussion. That's all it is.
Yes, and I was just wondering, from looking through though it, how much does it make sense, Mr. Bederow, that there is there, I felt the paragraphs that were put in the counter and in the response to the motion to dismiss, it feels like there was a lot of verbiage that was just used for maybe the public, because it wasn't necessary for, no offense, it really wasn't related to said like to their claim. They have the right to say whatever they want, but when you're putting in like the 4:30 a.m. and you're specifically bringing up a minor niece, but Karen, in my opinion, was at that specific time worried, and then she drops her basket because she goes back and they're saying, oh, well, Karen abandoned the minor niece and goes back to the property and finds Officer John O'Keefe. The opposite argument for that would be she is going out to look for him, and then she comes upon said scene, and she is traumatized and is in proximity, because if he is alive at said time, which was huge for me, just looking from a medical perspective, will there be a pain and suffering that will be tried to get from the O'Keefe family if if they're alleging he was alive versus that when he was struck, had it urgently and immediately had irreparable harm, and he was essentially in sum and substance not with us anymore at that
Well,
time.
look, the longer somebody suffers in agony and whatnot, yeah, I mean, damages go up, assuming there's liability. Certainly, if somebody were to suffer and it goes on and on,
Yeah.
I mean, it's just common sense. Yes, damages go up as opposed to somebody who may get struck by a vehicle and be killed immediately.
Right.
Neither one of those situations is good, obviously.
No.
But the idea that a loved one suffered in agony for an hour or two, whatever, is worse than somebody who is
For compensatory,
killed
yeah.
and didn't suffer. Yes, compensation increases with pain and suffering.
Okay. Okay, perfect. But then of course, so I'm devil's advocating and I go like this. I go, oh, does no one remember? Because we haven't done discovery and we're not depoting. And you write, and it was bullshit to write in the response that Karen Reed and her defense team went through painstaking, whatever, jump through hoops to make this stop while the criminal, case was going on. But at the end of the day, that was 100% agreed to by the civil judge. They agreed because she had she had criminal pending litigation, and that is customary. So it was all just a lot of fluff in it that I felt was unnecessary and not related to that claim.
I agree, but the argument that was put forth to dismiss those claims by Karen's lawyers was as ordinary, normal, and boring as it gets. So lawyers,
very boring,
nonplussed. Twitter trolls do what
just
they do.
Lost their minds. Absolutely.
It's nothing.
And
it really is
previously, Mr. Bederow, I think that anybody had thought maybe like that the a car insurance company, the lawyers, right, or whoever may or may not settle, right? After seeing after seeing Alan Jackson and Liza Little come on, I believe wholeheartedly that there will not be any ability, or there is no ability for Karen to lay down on this one, and she is not going to accept. If the insurance company pays, that's on them, but they don't. She has no. Yeah,
I mean, it's a wrongful death suit primarily, and you've seen her argument that she's not responsible in a causation sense for John O'Keefe's death. So why should she settle?
Right. No, but I think that's, but let's be perfectly clear. 90% do.
Yeah. But
90%.
if she has no legal responsibility, I wouldn't settle.
Yeah. I was really blown away. And then bringing up alcohol and alcohol consumption. It's like, well, babe, there has been 2 trials now and 2 acquittals. So if you're bringing up alcohol and you are bringing it's slippery. And I don't know really what the end game is.
None of this matters if she didn't cause John O'Keefe's death.
Correct.
Period. There's no case without that. And you're going to get a redux of the ARCA witnesses and all the other stuff you saw in the medical I mean, I don't find this state court civil case very interesting at all, to be honest with you.
Okay.
Because
I was going to ask you, do you think, because AJ said that nobody had asked for it to be to be televised, because I was like, can we see this? And I wonder, can we see this? Could for TV, could somebody pick it up or no?
I don't know why not. I mean, Massachusetts seems pretty liberal with televising.
Yeah.
I'm not sure why not.
See,
if it's in federal court, no. Federal court is never on TV. But
correct.
I don't know why a Plymouth County Superior Court lawsuit could not be on TV.
Right. Okay. Perfect. And anything, they pushed back the Matthew Farwell, to October 31st. We knew that. I am still very concerned, or not concerned. I'm just curious I believe something there is there, because there's no way he has not appeared There has been nothing that we have seen. I mean, something has to be happening, Mr. Bederow, behind the scenes, because it doesn't make sense. It's been too long. Am I right or am I wrong?
It's not common that a federal defendant would be arraigned in the summer of 2024 and as of the summer of 2025 literally not appear in court. Especially in federal court, they have a speedy trial statute. It's judges don't like to slow roll cases. This one has been, you know, I know they've claimed they're reviewing voluminous discovery. Are they petitioning to take the death penalty off the table behind the scenes? They could, although I don't know why that would need to cancel court proceedings. The other one is the obvious one. Is he attempting to cooperate? If he is, that's not something that they're going to advertise. You know, they do it a different way, other than, again, what all the Twitter yahoos thought about the leaky grand jury in Boston, where there's all this cooperation when they publicly announce a plea agreement and time served. No, it doesn't work like that. If there is cooperation, it works behind the wall, like this guy is either doing or not doing. He's probably attempting to cooperate. He's facing the death penalty. He's facing life in prison, if not that. If he has something to offer to save himself, would he try to do it? Any lawyer would at least explore that. That's probably what's going on, but I don't know.
Wow. And there was actually in that Morrissey dump, I posted one of the emails that he had sent to Tully, because Tully was on everything, CC'd on every single email that I saw. I'm sorry. I'm not going to be a witch, but everything, all roads lead to Tully, just saying. And there was one that was saying, is this true? And it was an article that
I don't think that was about the arrest. I think that was about some of the content in the article. I think people misread that. I don't think he was literally saying, "Oh my God, did he really get arrested?" I don't think.
No. It was the art. It was the content. No, of course not. I thought that I was like, I believed that Morrissey knew that he was arrested. I never thought that there was any question. It was a day later that he sent this. It was about the fact that it was concerning because there was no investigation. If he's asking if this is true in the article, what are you talking about? Is this true? It upset me. It gets me really going to think of the casual, the nonchalant kind of disregard to human life of a 23-year-old young woman who was pregnant, okay? Who had her whole entire life on the brink of womanhood, motherhood, who had been egregiously abused by a program that was supposed to be a safe haven and provide her parents, or her mother rather, with an after school of safety net. These mother truckers had the balls to say that she was in a partial weight bearing hanging when she had a broken hyoid bone, and they found it. I will never, ever
everything
that DA Morrissey is a decent human being. I think he is an absolute garbage human.
Everything they do is nonchalant. I mean, look at the current news of the day related to our case and the online commentary over videos introduced before a grand jury with changed names in a way to sound more incriminating. And there's just kind of a shrug of the shoulders, and that's their response. And, you get the commentary from certain idiots online who say, what's the difference? It's the content that matters. No, you have to understand there are, public YouTube presentations, as they call them, YouTube shows, whatever, and written stories that have titles and episode numbers.
Of course.
That are publicly available. And you have to understand that in October of 2023, they listed those publicly in a criminal complaint signed by Brian Tully, right? That's public information.
Yeah.
With the real names.
Of course.
Then, somehow, sometime later, they were sent a bunch of videos of these shows allegedly with file names that were changed to make it sound, harassing people, doing things which could be relevant to intent. And those videos, we're told Tully never looked at them. We're told nobody looked at them. Yet the evidence that was put before the grand jury used those changed names, which are inclined to suggest criminal intent. I mean, what's the biggest thing for witness intimidation? Your intent. And when the titles are changed from nothing to sounding like it's my intent to harass, how did that happen?
That's
How
intentional.
did that happen? So
Yeah.
who's responsible? The people giving the videos which are now deleted. How did it get changed? And so when these people say online, well, it doesn't matter, you have to understand how a grand jury works. Okay. There's no judge in a grand jury. The judge is the prosecutor. Okay. The legal advisor to the grand jury is the prosecutor. The grand jury is at the mercy of the prosecutor. But the expectation is that the prosecutor is an officer of the court and is going to act ethically, responsibly, and competently and fairly in presenting evidence to the grand jury. So when they introduce evidence that has been altered in any way without making that clear, and you give the grand jury the false impression that those titles, which are very incriminating, were created by the defendant that you're seeking to charge to show his intent, that's a big deal.
It is.
Okay? That is falsifying evidence. That is misleading the grand jury, whether intentionally or recklessly or negligently.
Oh.
Okay? And you have an obligation not to do that. And now those videos, they disappear. How did this happen? They don't have an explanation, right? But
No.
you have to understand, you have to go back to what happened before they got these videos. In the charging documents, they used the proper titles. They changed it.
Oh.
Okay? Now, you can draw your own conclusions, whether that's some civilian who provided them with the information, whether that's the prosecutor, whether that's Tully. But that's what was being said the other day when we're talking about future motions and why there has to be an evidentiary hearing. These people need to
Right.
explain this. Okay. And with all due respect to a prosecutor who says, well, Tully never looked at this stuff, that's not good enough.
No.
He needs to testify to that under oath and explain how in October he used the proper titles and how in November he used the other titles, and whether he looked at these videos or not, whether they disappeared, whether they didn't, what's the explanation? How did you get it? Did the prosecutor who elicited this testimony know? Who changed the titles? When was it done? All of this. So we'll be addressing that in due course, but that shows you a lot of the nonchalant type of attitude and behavior. I think somebody wants to pop in and say hello.
Hello.
Say hello just for a minute. You want to peek in? Okay, peek in. All right, hello. All right, goodbye.
Hi, Lovey.
Can I have some little bit?
Yeah, go ahead. All right. That's the 5-minute warning. That's the cute version of the 5-minute alarm clock.
That's the best. That's the best 5-minute warning we could have.
But,
But that's
you know,
huge
just-
because of the grand jury, though, that aspect of it, because if not but for in that
Listen,
those titles, could it
no-
have changed the outcome?
no serious person, no serious educated person, certainly no lawyer would ever say that it doesn't matter what the title of the video was. It matters what the substance. It matters entirely. Okay. And this is more just Twitter ignorance and just sheer stupidity by people who have no clue. You have to prove to the grand jury, who is the exclusive fact finder, what someone's intent is. And if you label videos in a very nefarious way and just introduce evidence like that, you are telling the grand jury or implying that the defendant is the one who did that. And if the defendant came up with titles that suggest obvious harassment, you can understand why a grand juror, ignorant to the truth, would say that's indicative of their intent. But what the grand jury doesn't know is that somebody, either in the prosecution, the state police, or their civilian friend or friends, altered and changed that in a way to make it sound nefarious, and that the prosecution had actual knowledge because in the charging documents a month earlier, they used the correct name. So,
Yeah.
so it matters. Okay. You have an
So much.
ethical obligation to present evidence to a grand jury fairly and accurately and not give them a false impression. And again, the prosecutor, they are the legal advisor to the grand jury. They are an officer of the court. So this is a very, very big deal. And so don't be twisted by some of these losers online who try to tell you that this doesn't matter because the substance is the substance. Now, the substance of a video is fair game. You know, the grand jury can look at that and say, here's what we think.
Yeah.
But that doesn't mean that you can rig other evidence to try to push it along in a way you want it. It
Absolutely.
matters. To go back to your point when you were talking about it, relating it to Birchmore, they're just very nonchalant and shrug their shoulders on a lot of these things and say, who cares? This is a very, very big deal. We will be demanding in writing all kinds of remedies, including an evidentiary hearing, compelling testimony of this entire cast of characters.
Absolutely. And as it should be, because the seriousness and the 105 years, I mean, there is a lot that should be answered for, because I feel as though, in my opinion, that Aidan Carney is being persecuted by the Commonwealth in this matter. It's weaponized. It has been a campaign. And that is my opinion. I know that you are not going to go there, but when you see the totality, let's go to the yellow cottage for a second. Oh, if you look at the totality of the evidence, sometimes the easiest answer is the one that is right in front of you. It's the Commonwealth. Okay. And the Commonwealth has done all of it, Aidan.
If you have a target you want to investigate and prosecute, go for it. God bless you. But do it ethically, fairly, competently. Disclose what you're supposed to disclose, all of it. When you give information in a FOIA request, if it's entitled to the defense, give it to us. Don't publicly release it and then argue it should be protected from you. That doesn't make sense, okay?
Yeah.
If you're going to introduce evidence before a grand jury of a video, don't alter the title, okay?
No.
Don't change the data. You know, does the grand jury know who did that? Does the grand jury know that the person who might have done that has a documented history of altering evidence in a way to harm the client? You think the grand jury should have known that?
Yes.
Or, so if you're going to alter it, tell the grand jury, or do what responsible prosecutors do in the first instance, present it as is, or don't present it at all. Just be fair. Do it fairly.
Absolutely. Absolutely. You don't ask to be here. You just show up and go where they tell you to, because you are.
We go where they send us.
Absolutely. And in my opinion, we get more and more Chinatown every single day. And I appreciate you, Mr. Bederow. And I appreciate our little Bederow. She is adorable. I know you're a hard stop today, 8:45. I appreciate coffee, tea, Mr. Bederow, and me. You're my favorite of all time. Have the best day.
Thank you. See ya. Bye.
Bye. Loveys. I am not worthy to receive you, but only say the word and I shall be healed. His name, Attorney Bederow. His occupation, favorite, goat. Okay. Is he the goat? Yes. I love him. Okay. That was weird. Don't make it weird, Kim. I wish you a magical day. It is before 9 a.m. Go off. Be kind to one another, or troll each other. Do whatever you want to do. Okay. I don't give a shit. But Did want to say thank you to Mr. Bederow for not charging me an appearance fee. Have a great day, lovies. Bye.
All right, great job on the news.
Thank you.
We will, Courtney and I will share what happened when we went to dinner last night, Sunday dinner coming up. And as